Okay, everyone, welcome. We have 20 participants at this time. I think some others might come in. We acknowledge that it's for some of us the end of the day. So we will make the best of the energy and the dynamics in this very challenging session. It's on human rights and the use of biometrics in counter-terrorism. Short introduction, my name is Fulco van Deventer. I'm the co-founder of Human Security Collective. It's an organization, an NGO based in The Hague. I'm looking forward to this meeting, a dynamic and interactive session, and hopefully it will be well supported by all the digital means that are necessary. What I earlier said, we acknowledge that's the last session from the first day, and that some participants might feel the notorious end of the day Zoom fatigue that I'm always aware of in this COVID time. In this session, we will discuss the findings of the KMF-funded project focused on human rights implications of the use of biometrics in counterterrorism. I want to highlight that this project was conducted in support of the Special Rapporteur on Counterterrorism and Human Rights and explores ways to further a human rights-based approach to existing, emerging, and of course future uses of biometrics. I suppose that we are all familiar with the application of biometrics in our daily lives, like digital fingerprints, facial voice recognition, and iris scans during travels or asking for IDs, etc. But the human rights implications of these data at each stages of uses like collection, retention, processing, and sharing is probably not so well on our radar. And certainly needs further discussion, research to influence legislation and policy. We will deepen this topic during this session. Let me give a little insight in how we are going to design and how we're going to run the session. We will have an introduction on the project and the findings by the mandate of the Special Rapporteur on Counterterrorism and Human Rights, Ms. Fionnella Neolane. She's based at the Human Rights Center in Minnesota, and she's currently there. Then we have a panel of 5 interesting and eloquent speakers, all working in and on the intersection between biometrics and human rights. To start with, I don't know if it's the secret, yeah, it's Ilia Siatitsa. She's now in Geneva. She's program director of the Government Exploitation Program of Privacy International. Then we have Daniela Eilberg. She's in Sao Paulo, senior researcher at the Data Privacy Brazil Research Association. We have Karen Melchior. She's at the time in Copenhagen. Normally she's in Brussels. She's member of the European Parliament. We have Joaquin Zuckerberg. He's at the time in Vienna, program officer at the Terrorism Prevention Branch at UNODC. And we have Edward J. Flynn in New York. He's senior human rights officer at UNCTAD. A warm welcome to all speakers and looking forward to your input. In the first round, all panelists will give a brief view on what they think are the biggest human rights challenges in the use of biometrics, in the context of their work, of course. Then we will have time for a brief Q&A, room for clarification on the input given by the panelists. This will be continued by the second round, in which we explore how human rights compliance for government and states can be improved. After this round, we have ample time for interaction by all participants. We would like to ask the participants to raise your question in the chat box, as you already did in other meetings probably, and we collect them and address them through the technical team during the Q&A. Take in mind that this session will be recorded and made public through the knowledge platform afterwards. No Chatham House rule applied. That's it for now. Let's start with the introduction by the Special Rapporteur on Counterterrorism and Human Rights, Ms. Fionnella Neolane. Please, Fionnella, the Zoom is yours.
Thank you. So I think we're going to get an image on the Zoom, and that's great to see. Thank you all. So first of all, I want to thank my many colleagues and friends who've joined the panel. The mandate is really grateful for your engagement with us on this issue. As the introduction speaks, the panel consists of those working within the UN system, UNCTAD, UNODC, with whom we have strong working relationships, but also as representative of civil society, of legislatures in the global sense. And these voices are extremely important on an issue that is of particular relevance, I think, globally, all the more so perhaps in a time of COVID. I also want to thank KMF. It's obvious to say the mandate comes with very little resources. We're special experts who do not have budgets for additional research. And so having the capacity to undertake this kind of work supported is a really vital way for us to be the human rights voice on an issue that often lacks a human rights dimension. Let me also thank the researcher who led the work, the legal advisor to the mandate, Christina Hertzi-Orban. So with that, I'm going to go to the second slide and really talk about what drove the mandate to engage this work. So in many ways, counterterrorism, as many on the panel and many listening will know, is driven by a set of, if you want, legal or policy imperatives. And many of those are not driven, not only are they driven nationally, but in particular post 9/11, we've seen the United Nations Security Council play what one might call an outsized, and what the mandate has called, legislative role in the development of the legal and policy framework around counterterrorism. In particular, we've seen highly expansive Security Council resolutions that, in the sense that they take a legislative role, they are requiring states to implement certain processes and procedures. And those processes often have really significant impact on domestic legal regulation. And so here what you see is a slice, a paragraph from UN Security Council Resolution 2396 of 2017. And it, quote, as you'll see, decides that member states shall develop and implement systems to collect biometric data. So at one level, I just want to point out the obvious, that that's quite an extraordinary diktat, in the sense that there are many national legal systems, perhaps I think of my own Ireland, where it would be very difficult, I think, to get a national agreement on the requirement of, if you want, wholesale collection of biometric data. And as you'll see, the resolution also sets out what that collection might include, but it includes fingerprints, photographs, facial recognition, and other relevant identifying biometric data. And bear in mind that that's could include leaving open the possibility that other technological developments or other methods might be used. The resolution also makes clear, and the language is underlined for you, that this should be in compliance with domestic law and international human rights law. But it doesn't specify, as Security Council resolutions rarely do, what that actually means in practice. And one of the mandate's greatest concerns has often been that human rights appears like a decorative fringe in these resolutions. We invoke these two words, human rights, like talismans, but we often don't specify what's required of states. So this report was really driven by the need to fill that gap, to identify precisely what the human rights obligations of states and of businesses would be. So let's go to the next slide and talk a little bit further about the premise that why is it so important that we protect human rights in this space? Well, I think it should be obvious to all of us that biometric data is highly sensitive. There are things that one can know from one's biometric data that are essential to the privacy, the dignity, and the definition of personhood. And while many people, increasingly in time of COVID, as we see with the development of various kinds of apps tracking that data, people seem anxious to give away sensitive data, often driven by fear. Actually, we ought to have, all of us, everyone listening, ought to have a really profound understanding of the consequences of such data being given away, and ask some really obvious questions about who's taking the data, who's storing the data, who's using the data, who's sharing the data, and what the consequences for a whole range of our human rights might be as a result. And so from a human rights perspective, we see biometric data as really essential aspects of human personhood. And at that level then really requires us to think about these technologies as high-risk technologies that are deserving of the highest levels of human rights protection. But not only that, that their use should have human rights hardwired in from the beginning, given the essential and absolutely personal nature of the data. So let's go to the next slide. as we move through. And so as we think about the human rights implications of using biometric data and tools, it's important, I think, to think about where do we start with the list of human rights, or the sort of the universe of human rights protections or concerns that are implicated. And often when we talk about the use of biometric data, there's an assumption that really the major human rights issue is the right to privacy. And I want to stress that the right to privacy is a really important aspect of thinking about human rights in biometric context, but it is not the only one. And for many, and particularly for the mandate, I think of human rights as what I would call a gateway right. It's a right that opens up to other rights, because by the safeguarding of privacy, we ensure that a whole range of other rights are protected. Those include, for example, the right not to be discriminated against in the use of biometric data technology, the right to be treated equally as a result when biometric data is developed, used, shared, transferred, but also that once biometric data is in circulation, its capacity to impact on the most fundamental of rights, the right to fair trial, the right to family life, the right to religious expression, the right to social and economic rights, all of those things may be implicated by the use or misuse of biometric data and tools. And it's also important, and the mandate recognizes that there's a significant overlap here between privacy and ensuring data protection. But that's a sufficient but not necessary condition of human rights in this space. And I do want to harken back to that Security Council resolution. We have a global mandate for collecting data, but no global mandates that there be data protection in most of the jurisdictions that are in fact going to engage actively in the collection of data. So we would make a particular, and I here recall the report of my colleague Tendai Achume, the Special Rapporteur on Racism, whose report to the Human Rights Council earlier this year focused on the racism and the discriminatory impacts of new technologies. And to say that my mandate is also deeply concerned about the negative use of these technologies, which can amplify the existing discriminations and marginalizations of certain groups and people that include religious and other minorities and people in particularly vulnerable situations. And that caution is all the more amplified at this time of global pandemic. Let's go to the next slide, please. So what would a human rights approach to biometric mean? Well, I think it means a number of things, and they're laid out here, I think, and I hope that we can discuss them more in the Q&A. First of all is that we need a comprehensive human rights approach, which is at every single stage of data use, collection, storage, and transfer. That means that you need to address at each one of those stages whether the interference, because the data is per se data collection is per se an interference with human rights needs. So we make sure that at each stage that there's a human rights assessment. And one of the things that we see very forcefully is that states and UN entities, many of them proposing the human rights approach, tend to focus on one stage, not see the interconnectedness of all of these stages, and that each stage requires this kind of human rights assessment. And what that means is comprehensive human rights risk and assessment. We're also very clear that a human rights approach has to govern all phases, and I particularly want to focus on phases of design and development, and to think about the hardwiredness of some of the human rights concerns in this space, including who's developing these tools, the geographies of where they're being developed, mostly in the global north, aimed at other countries. Mostly, I want to say, as a scholar and a practitioner focused on gender, mostly developed by men, not women, and the deep concerns that have been addressed by myself and my colleagues, special rapporteurs, around the design phase and the ways in which many of these technologies have profound flaws in relation to equality and non-discrimination. I think I also want to say that a human rights approach makes clear that we should not, and we shouldn't be encouraging, supporting, capacity building, or enabling states to use these technologies unless their human rights compliance can be demonstrated. And that's a particular caution to the due diligence requirements for UN entities when they engage in this work, not least because, and mandate has had communications with a number of states on this issue, the already demonstrated misuse by states of surveillance and other techniques in the counterterrorism arena that should give us real pause and caution when those states are going to engage in comprehensive biometric data collection. And I do want to point out for those civil society members listening to this, that one of our greatest concerns in this is the use of these technologies against human rights defenders and civil society actors, a well-trodden path in the CT area, not a retail problem, but a wholesale problem in the misuse of counterterrorism law and practice globally. So let's go to the next slide. We just have two more, and I hope, Fulco, I'm in time. I have. So we'll get the final two slides up. First one first. So we've talked a lot about state responsibility, and state responsibility is an important piece of this conversation. But I think one of the unusual things about this report and why it's, I think, makes a significant contribution to this debate is the recognition that business and corporate entities are playing a really important role in this space and that they are significantly under-regulated in the space. I just want to pause and say a little bit about why it happens that way. It's not by accident, of course it is, that much of the technological innovation and drive is coming from the private sector. But I think we're also would start with the premise or caution that it is often convenient for states to have the rights and responsibilities associated with practices that impact human rights being held in the private sector and not seen to be state responsibilities. And the mandate, I think, would very clearly say that's not the case. There are clear human rights responsibilities here. The first, of course, is the obvious requirement that states regulate their businesses in a human rights compliant way. And here we do have human rights language and standards that help us sort of navigate the responsibilities of the private sector in the biometric area. And these are the UN guiding principles on business and human rights. And they're non-binding, but they are authoritative. And we think it particularly important that the actors in the CT space are aware of these responsibilities as the regulation, the collection, the use, and the storage is actually falling in practice to the private sector. So first of all, we need businesses to give us explicit and public policy commitments to meet their responsibility to respect human rights. And what that means is not just nice public statements, but actually that's hardwired into their operational policies. We need businesses to engage in risk assessments that actually assess in meaningful and fulsome ways the potential and actual human rights impact of data collection in the biometric space. And that includes both direct and indirect assessments. And again, that's across all phases. It's not one, it's development, design, use, transfer, and storage. And I think that's really important because there's a tendency to cherry pick in these areas where states will be compliant. It's also really clear, we've certainly seen this in the content moderation area for many tech companies, a lack of transparency or even a lack of internal accountability on the implementation of human rights policies. So terms of service are not enough here, and clear articulation of what those standards are and how they will be implemented and how people and individuals who are affected by them can access those standards is really critical. And that needs to be shared, it needs to be public, and there needs to be dialogue about the absence of those standards at this time. So let's go to the final slide. And then we will close out. We've talked a little bit about what businesses must do, the general obligations of states. Let me close by talking about the really fundamental safeguards we have to have. It is absolutely clear that states have to set up and implement authorization and licensing systems that govern these technologies that have a high human rights risks. And those systems have to apply to the entire spectrum. They have to be, these kinds of tools have to be presumed to be high risk. And as a result, the kind of standards that apply to them have to be fulsome. It's clear that those authorization and licensing frameworks have to contain binding obligations. These frameworks should be developed through a human rights conscious approach that engages with civil society and key stakeholders who are human rights stakeholders in the development of the technologies. And these frameworks, in our view, have to set in place inbuilt safeguards that protect us against abuse of these technologies. And that includes independent oversight and transparency. And that transparency is what will allow us to safeguard and to ensure the protection of human rights in this space. So let me stop there, and we look forward to hearing what the panel has to say and their own views on how we regulate this space.
Thank you, Daniela. Thank you for your very clear introduction on the subject of biometrics and human rights. Complex, but you brought it in a very understandable way. Of course, all the details and all the background can be read in the report. But now let's go, as you say, to the panelists. Ilia, I would like to ask you the question that we have set out. What are some of the most salient human rights challenges related to the use of biometrics that you experience in the context of your work? Please unmute, Ilia.
Yes, thank you.
Yeah,
so thank you very much. Let me start by thanking the organizers for this invitation and to express Privacy International's support to the mandate's work on this issue. It's crucial to have this report out and to have the opportunity to be discussing those issues. Privacy International, or otherwise PI, is a London-based non-governmental organization that works globally at the intersection of modern technologies and human rights. So we have been for a while now been monitoring the development of biometric data identification systems across the globe as part of counter-terrorism strategies, but also migration management strategies, and more recently, pandemic management strategies. And concurring what just the Special Rapporteur just mentioned, what we have observed and concerned us is that more often than not, these biometric systems are introduced without appropriate legal frameworks that can protect the rights to privacy and data protection. Either because there is no legal framework in place, but even when there are, and last time we counted, there are about 130 laws across the world protecting privacy and or data protection one way or another. However, many of these frameworks do not even mention biometric data, and as a result also they don't characterize this data as sensitive data that require enhanced protections. And additionally, many of these frameworks contain exceptions with regard to processing of data by law enforcement, all for reasons, broad exceptions such as national security or fighting serious crime. A robust data protection could provide protection so that this data will not be used for more than the intended purposes. Or also regulate third-party access to this information. This, however, is not happening at the moment. Actually, on the contrary, what we've noticed is a constant repurposing of various databases with no concerns about the impact on people's human rights, and not only privacy. A blatant example of that was when the European Asylum Dactyloscopy database known as Eurodac, which was established in 2004 to facilitate application of migration management in Europe, in 2009 was made accessible for law enforcement purposes, and in 2020 we've seen EU financing plans to make different databases interoperable and easily accessible by different actors in different places. and there is little information regarding how access will be regulated. Let me conclude, so I don't want to take more time, that as it was already mentioned, unlike a passport, individual biometrics cannot be easily changed. Facial fingerprint data are basically transformed by these technologies to machine readable identifiers, but these are fixed and unchangeable physical features. So unauthorized access or major breaches actually can have major implications, and that cannot easily be rectified, not as easily as changing your password. I cannot change my face that quickly, for sure. So impact assessments shouldn't be an afterthought in the process, and quite often we've observed they've been. And just to conclude now for real, let me underline what also the rapporteur already mentions, that we don't see intrusions to privacy as monolithic, but actually they provide a gateway to the violation of other human rights, and can have a very serious implications to the entirety of the life of people, and not just that their biometrics has leaked. And this is why having data protections is so important. Thank you very much.
Thank you so much, Ilia. That was very clear. I want to pose the same question, Daniela, to you. What are for you and your work, I think mostly in the Brazilian context, the most salient challenges?
Well, first, I would like to thank you for the opportunity to be in this conference. It is an honor to share some experiences and knowledge with this panel composed of experts in this field. The national security speech is a worrying point in countries where authoritarianism has grounded the state building. And Brazil is one of the Latin American countries that has been unable to fully reach the democracy transition. And it is no coincidence that our current code of criminal procedure dates from 1941, a time of dictatorship. That is probably the reason why, or even the consequence of, we can identify the national security ideology in our criminal procedure, which seems to assume the same position, the same security point of view in terms of coercive measures and means of obtaining evidence. So this is the first challenge I highlight. The new technologies and the use of biometrics linked to the criminal sphere is done mainly through the evidentiary law field. And here in Brazil, there are some misunderstandings among the concepts and limits of national security, public security, criminal procedure, and criminal investigation competences. So it is exactly with the regard of this authoritarianism heritage and the structural racism that we have here in Brazil that we should face and be aware and face the criminal procedure and the new technological advances in terms of coercive measures, means of obtaining evidence, and security policies in our criminal system. Facial recognition, for example, seems to be the trigger and the trend used in the last years. And evidence of high rates of false positives and mainly revelations around the reinforcement of discriminatory practices from predictive policing culminates on the manifestations of various organizations of the civil society on the subject, as Data Privacy Brazil research. So I would like to delve into some of the implications of this increased surveillance on human rights by suggesting that the criminal investigations are turning into criminal techno-surveillance, which is precisely the focus of my PhD dissertation. So globally, we often see the governments using intelligent resources to establish political surveillance in the name of national security and public security. And regarding especially key themes of biometric and some of the legal approaches here in Brazil must be raised. And biometric data here are considered sensitive data, and according to our new General Data Protection Act, the only cases in which they can be collected or shared without the consent of the data subject are in specific situations such as public policies and health protection. And here I highlight the second and the last challenge that the biometric data in Brazil are strongly associated with the concept of citizenship. In our country, they are collected by different government agencies and used for various purposes, as the ADC report has already called attention. So fingerprints are collected by the Public Security Department, the State Traffic Police Department, the Federal Police Department, and the Electoral Justice Courts in order to prepare the national identity card, the driver's license, passports, and voters' cards. However, this data collected by the electoral justice for the exercise of the compulsory vote, here in Brazil is compulsory vote, for example, this data collected have been used and shared for other purposes, especially for criminal investigations. And that has been done without any transparency, public control, or security measures, representing a substantial violation of the principle of legality. Thank you.
Thank you so much, Daniela, for giving us the insight from Brazil today. I would like to switch to Karen from the European Parliament. Karen, can you give us your view on the most salient challenges?
Thank you very much, and thank you very much for inviting me to this discussion and to the great work by Professor Daniela and Eilberg on the report. I mean, we have, as was also mentioned earlier, a large use of biometrics data in use of facial recognition, fingerprints, and also DNA recognition technologies in our EU Schengen information system, which was reformed in 2018. It did also, during the reform, introduce stronger protection rules, but I'm afraid that the protection rules are not really at the level that they need to be when we're talking biometrics data, because as it's been highlighted earlier in the panel, biometrics data is unchangeable, and it was sort of a machine readable, as I think Elisa said, identifier of each individual. In 2020, this year, the European Union's ICT Agency for Internal Security and Border Control signed a framework contract for a new biometric matching system, which aims to create a database of fingerprints and facial images of more than 400 million third country nationals by 2022. And recently we've had an introduction of an EU migration pact, which one of the elements is a stronger border control system. And I'm quite afraid that there will be a move to further digitize European borders with collection of biometric identifiers. And this data can then be used for, as they say, fighting crime and counter-terrorism. But I'm also afraid that they can be then later used for other purposes that were not the purposes originally collected. And also, if we then share the data that is collected about third-party nationals with these third countries, then it will be quite difficult to, if they are being, if they're human rights defenders, if they are opposition politicians, if they are journalists, then we need to make sure that we're not endangering these people's lives in order to ensure faster returns on people that have arrived illegally. And the large focus that there is on closing down the European borders might lead to an overreach of use of biometrics data. And as was mentioned as well, every step of the way where we use data, where we use especially biometrics data, we need to have a human rights-based approach to the use of data. Furthermore, I think it's also really important that when we regulate other issues, not just counter-terrorism and border control, that we look at the way that we use data and also how we regulate the businesses using biometrics data. It was mentioned the terms of service of different platforms in regards to control of content and taking down content. I think it's really important that we make sure that, for example, facial recognition is not used excessively, and also that we have very clear regulation on how the platforms do this. We're at the moment preparing the negotiation for a Digital Services Act, which will be which will be regulating platforms such as Google, YouTube, Facebook, Twitter, content hosting platforms, and also others. And I think it's quite important that we think about the human rights aspects, both in terms of freedom of expression, but also the protection of personal data, especially personal data as sensitive as biometric data. Thank you.
Thank you very much, Karen. I want to step to UNODC. Joaquin, can you give us your insights from your perspective?
Thank you. I also would like to thank the organizers for inviting the UNODC to this event. I wanted to focus today, talk about some concerns about the use of biometrics in the border control area, which is one of the areas of work of UNODC's terrorism prevention branch. In a sense, I guess I'm going to be fleshing out some of the general concerns raised by the Special Rapporteur and some of the previous speakers in the area of border control and CT. Now, as you know, biometric technologies are used progressively more and are highly adopted at international borders. And now, despite the many advantages of biometrics, their use, as was mentioned before, raises many concerns. Now, the integration of biometric information systems employed by border control leads to, as was mentioned before, increased surveillance that involves collecting and storing personal data such as fingerprints as individuals cross borders, apply for visas or request asylum. Thus, although biometric technology has been proven to be cost-effective in enhancing border security, detecting fraud, helping improve border crossing efficiency, as well as enabling effective migration control and enforcement, biometric technology has indeed serious impacts on privacy and data protection. Now, a breach of such personal and confidential information would violate the principle of the right to privacy. Now, from a legal point of view or international human rights point of view, the right to privacy, as many other human rights, is not an absolute right, and hence it can be limited by law, and member states have been doing that. Now, however, such limitation has to be done on the basis of provisions, including the ones in the United Nations International Covenant on Civil and Political Rights, and similar ones in regional treaties and national constitutions as well. Also, as per human rights decisions by human rights bodies, regional and national courts, which have developed a test to establish whether a measure limiting non-absolute rights such as privacy is legitimate or not. It's also worth mentioning the existence and effectiveness of procedural safeguards, including judicial oversight, which are also a key aspect of the assessment as to whether the limitation of the right is proportionate. And this is also a problem when in the area of our work we see many national frameworks which lack that judicial oversight. And obviously, as mentioned before, measures that are discriminatory on prohibited grounds, such as religion or ethnicity, will fail the test. Another concern is also related to the potential for what people in this area call function or purpose creep, which occurs when personal data is collected for one specific purpose and subsequently used for another unintended or unauthorized purpose without the user's consent. Now, biometrics are obviously likely to strengthen the potential for function creep due to the very sensitive nature of the data collected and the possibility to use centrally stored biometric data for purposes other than the original purpose. For example, in the area of our work, border crossing. Such databases offer also more attractive targets for outsider attacks and insider misuse. So I think that's basically, some of the areas of concern when it comes to our work in CT and border control, and I'll be happy to answer questions during the questions and answers period. Thank you.
Thank you very much, Joaquin. Very clear. Let's go to the other UN entity on board here, UNCTAD, Counter-Terrorism Executive Directorate. Edward, we are very interested in hearing your view on the most salient challenges on human rights while countering terrorism. Please, the floor is yours.
Thank you so much, Fulco, and thank you to the Special Rapporteur for producing this really important report. And I'm grateful to be a part of this distinguished panel. I'll be very brief because I know we want to have a discussion here. But this event is extremely relevant to the work of my institution, the Counter-Terrorism Executive Directorate. We are mandated, in fact, by Resolution 2396 to follow up on these obligations. And so we are looking very closely at how states are applying the mandate in 2396 in the area of biometrics. Actually, next week, our executive director, Michelle Konings, will be delivering the keynote address at the Biometrics Institute Congress. And so we are really digging deep into this issue. But as the Special Rapporteur laid out so clearly, and other members of the panel, there are incredible challenges in this area, and we really have to figure out an effective way to respond to them. And I'd just like to add to some of the perhaps more evident challenges, such as privacy and data protection questions, etc. We recently put out, not that recently, a couple of years ago, a biometrics compendium, which addresses the responsible use of this technology. And this is a discussion we've had in our office and with member states about the use of this term responsible and using this data responsibly. It also appears in Resolution 2396. And the question could be posed whether responsible use is exactly the same as use in compliance with human rights obligations, or does it mean something else? I mean, I must be frank that we include that term in our dialogue with states. But it is a little unclear, and in particular, I think use of the term responsible raises the question of responsibility and accountability. And I see that our colleague Sangeeta of the Human Security Collective put a question to us about accountability, and I think that's an important question for us to consider. What are our options in the case of violations or gross abuse of this technology, either by governments or by companies? So, you know, we can imagine that, that there could be cases of wrongful arrest and detention, harassment, prevention of the right to travel, many consequences for the irresponsible use. So how do we assert that? And then just secondly, just very quickly, I have to say that in our work, we engage obviously with all member states. And the international dimension is a challenge for us. What should we advise states to do? I mean, the resolution mandates that this data is shared internationally. Well, different states obviously have very different standards. So how is one state to deal with another that uses biometric data in a grossly disproportionate or improper way? And who is to make that determination? So that's another big challenge that we face, and I'd just like to put that out there. Thank you very much, folks.
Thank you, EJ. Thank you very much for highlighting the responsibility and accountability and also the different standards on this between the states. I think before we go to the next round, we have two good questions on the chat box. There might be more, but let's take them up now. I think about the first question. It's about the tech giants avoiding taxation via smaller countries mentioned here, Ireland and the Netherlands. Do these small states have a form of leverage to help enforce human rights in this space? Karen, from the European perspective, would it be a question that you would like to answer? Oh.
I would love to answer it.
Please step in.
I was actually trying to find out where I could raise my hand. I think this is a really good example of why we need greater international cooperation on these issues. I just read that the OECD is coming out with new taxation suggestions on international corporate taxation. And I think we need to have an international taxation system that is adapted to deal with these big technological companies that are now have turnover which is equivalent or larger than small nation states' GNP. And I think also when we're looking at questions as such as sovereignty on digital products and infrastructure, that we need to look at the purchasing power of these countries and the way that they're able to give aid to different branches of their company, a little bit like the rules that we have on anti-dumping and state aid regulation between states. And also one of the issues that there is little leverage from small countries where they put their headquarters is the protection of data, where we saw with the GDPR, the data protection regulation in Europe, that we are wanting to have regulation at a European level so that we can help the data protection officers nationally to protect data better there. And at the moment, we're moving towards, as I mentioned before, a broader tech platform regulation, both on marketplaces, hotels, listings of properties, but also on content, so that we have better assurances that it's not just the terms of service that rule what's going on, but that we also have, for example, either independent dispute settlement bodies concerning the content, and that we have a clear link to the legislation of nation states, so that it doesn't sort of go into a space of commercial legislation where human rights and also the sort of protections that you have at a normal court system go out the window.
Thank you very much, Karen. Very interesting. Let's go to the other question that was already mentioned by EJ. It's the international human rights law. Is that well equipped to provide redress to those caught up in the machine learning targeted decisions? So do we need to rethink redress or dispute bodies, what was already mentioned, as well as accountability mechanisms? Who of the panelists wants to jump in here? Just unmute and you can speak. Ilia, yeah, please.
I can have a first go at it, but it's going to be the conservative view.
No problem.
I think in order to assess whether they're well equipped, we may need to make sure we are already using appropriately all the tools the human rights law, human rights standards are giving us. And I think they're giving very good guidelines on how this kind of new approach to machine learning targeted decisions need to be taken. So I don't think we need to go and reinvent the wheel at the moment, starting with, okay, the more targeted, but it's also, in my view, narrow response to that the GDPR gives on automated decision making, and how this and the safeguards the GDPR puts when such decisions are taken, and then moving then to the standards that the human rights law already put with regard to redress, that there needs to be meaningful and effective, and that you will have to have the possibility to challenge that decision in equal means. I think these are already in a very good place to be the starting point for dealing with redressing injustices there. Which, and I'm not saying these are sufficient, but it is definitely a beginning.
Very good. Thank you, Ilia. Fionella, you want to step in here?
Yeah, I was just going to say, so I think I would agree with Leah that we do have clear obligations of redress and remedy by states under treaty law. And I think the issue is, of course, the application of those, particularly in counter-terrorism contexts, are, I think, often quite challenging. I think the place where redress is also really most challenging is involving private actors. And I want to make an analogy here to what we've seen, for example, in the content moderation space with large tech companies like Facebook and others, where essentially redress has historically been in the quote terms of service agreement. And often it's very unclear, for example, if you're taken off a platform, where you can actually go to have redress. We've had the mandates had a long-standing dialogue, I would put it that way, with some of these companies about simply putting on clear clearly online what the mechanism for redress is. Some companies actually don't clearly have mechanisms for redress where you can challenge. If they do, they're highly cumbersome for an average individual to manage, and they may not have the resources or capacity to undertake them. So I think one of the really big gaps here is the regulatory gap in relation to private entities being required to provide clear, legally defined, adequate redress when the private use of these technologies by private entities has public effect on individuals' capacity to exercise their human rights obligations. And there we have a massive gap that is in dire need, I think, of redress, whether it's at the national, regional, and at the global level.
Thank you, Daniela. I think with the answering of this question, we're actually stepping into the round 2, where we're asking for exploring ways in which human rights compliance on part of governments and business enterprises can be improved. So this is already one of the issues we should think about. Let's go into round 2. After that, there will be more time for Q&A. But let's ask the question. So what are possible ways that human rights compliance towards government and business can be improved? Karen, I want to come back to you, please.
Thank you very much. And I mean, this is perfect to be following up on the professor's remarks concerning private actors, because this is exactly what we have been working on in the Parliament, trying to see how do we have an option for the users to actually question if their content is being taken down. How is this done? Is it in an easy way? How do they make sure that what the criteria for taking down material, that it is only illegal material that is being taken down, or that there is some control of the terms of service, that it is not just all material that is politically unsuitable and therefore restricting the freedom of expression, and that there is a link to the justice system so that the rights can be actually upheld. And I think this regulation of private actors in the human rights field is very interesting, seen from the European Parliament side. And from the European side, we're also looking at corporate governance and due diligence on human rights in the production chains. And this is something where we're trying to say, okay, the values that we have in Europe and the single market that we have, how do we make sure that we get the market to actually help protect our human rights and make sure that the private actors are not countering them or exporting abuse of rights elsewhere in the world, and therefore, and by importing the products afterwards. I mentioned in the first bit of our discussion the establishment of a border control system and reinforcing the digitalization of the borders, and this is an area where I think we need to be very much aware. And then we're also beginning to look at regulation of artificial intelligence applications, also on the use of remote biometric identification, where there has been the Commission has said that we're going to do a moratorium for a while, for I think 5 years. There is also a call for a ban. And I think we need to look carefully at the use of artificial intelligence with biometrics as a high risk area, because as was mentioned earlier, it is, you can't change it. And I think there is need for having strong regulation on this. I mean, there are 2 committees in the Parliament that is working specifically on this, the Uri committee, where I'm a member, and then also the Libe committee that deals with fundamental rights. And the European Parliament is one of 3 legislative branches of the European Union that can sort of set the frame for the member states. And hopefully, if we set good European standards, we can influence also what's going on in the rest of the world. Thank you.
Thank you, Karen. Joaquin, can I go to you and see what are the ways forward from the UNODC perspective?
Sure, thank you. Now, in terms of thoughts to facilitate better human rights compliance, basically, I just wanted to very briefly discuss the type, again, relate to the type of work that UNODC does, which in our case is we don't work so much vis-a-vis private companies, but it's the provision of technical advice to member states. So part of the technical advice provided by UNODC is precisely the harmonization of domestic law with international human rights, specifically in our branch, the terrorism prevention branch, dealing with counter-terrorism. Currently, we are implementing 2 different projects, promoting the implementation of Security Council 2396 among member states, which also has to do with the use, in addition to biometrics, it has to do with the use of advanced passenger information and passenger name record. The use of biometrics is one of these project's components, together with the use of watch lists and other databases. And again, these projects aim to deal with the challenges to effective coordination and collaboration among national authorities that can negatively affect the identification and detention of suspected terrorists. Terrorism, again, is the focus of our area. And the objectives are also to strengthen the member states' criminal justice responses against terrorism. Now, generally, what we do is we work. Our project beneficiaries are national counterterrorism agencies, law enforcement, security and national institutions with a border security mandate, as well as other national ministries with relevant functions. The programs, as kind of related to the comments I made in the first round, deal with the development and analysis and review of normative frameworks on both biometrics, but more in general passenger data, and again in line with international standards and human rights considerations. There are certain standards and recommendations, practice recommendations by the ICAO that are in place. They include, as in the comments that I made in the first round, the purpose for which, for example, passenger data might be collected and used, the definition of a data retention period, mechanisms, safeguards and procedures enabling individuals to exercise their rights in relation to data privacy, and the protection of personal data in case of unlawful processing of their, for example, API and PNR data by the state authorities. We also deal with the designation of a supervisory authority with the function of carrying out an independent oversight of the processing and protection of personal data, the provision of the use of sensitive personal data, except under very clear and precise circumstances, and the obligation of the competent authorities not to take any decision affecting significantly the rights and legal interests of an individual on the sole basis of the automated processing of his or her personal data. So in other words, in a nutshell, these are all the issues which again have to do with the way states should be regulating biometrics, personal data in general, but biometrics in particular. And these are again answers which need to carefully balance human rights principles with any of the principles that were mentioned before: national security, health, etc. Thank you.
Thank you, Joaquin, for providing these very clear examples. EJ, I think that CTED in its implementation and facilitation of the 2396 resolution is in line with UNODC, but probably you can add something from the specifics of CTED.
Yes, just very briefly, thank you, Fulco. I mean, we work very closely with Joaquin and UNODC on advising states on strengthening their legal measures, but there are just two points I'd like to add to the discussion. And one of them is so fundamental to this topic, I think, and that is simply transparency. We talk about it a lot, but it cannot be overemphasized. There was a lot of criticism of the adoption of Resolution 2396 itself, because, as everyone knows, the Security Council processes are not sort of famously open and participatory, and there wasn't a lot of input from other actors into the adoption of that resolution. But there has to be more engagement with other actors, and there has to be greater transparency in this field. As we all know, technological advances are moving at a lightning pace, and it's difficult for all of us, for governments, international organizations, civil society, to keep up. And some states have, the UK has a biometrics commissioner, which is mandated to oversee these sorts of topics, but there is still a deficit in transparency. So we really have to look at ways to keep the public better informed about how their data is gathered and used. We have to find ways to support parliaments, and I'm very impressed by what Karen had to share with us, but we have to do everything possible to support parliaments in keeping up with the rapid pace of technology. And secondly, and this is pretty obvious, but we need to strengthen our coalitions and partnerships in this area. CTED was fortunate to be one of the founders of a consortium many of you know called Tech Against Terrorism, which deals with mainly with content moderation issues, but we were able to put together a coalition of companies and governments to look at these issues. You also have the Global Internet Forum to Counter Terrorism. There is the Biometrics Institute, and as I said, our executive director will be addressing their Congress next week. The Institute brings together governments and the private sector very effectively. I don't think there's a lot of civil society participation in their work. And so I think that we need to find ways to bring civil society more directly into this conversation in all possible fora, at the UN, in parliaments, and what have you. I think we just need to strengthen those partnerships. Thank you, Fulco.
Thank you, EJ, for bringing up transparency and especially engagement with civil society on this issue. Fionella, can I jump to you and have your opinion on this?
Sure. I think one thing I do want to stress before I talk about sort of some specific areas is just to remind us what we talk about, and what's prompted this work has been the use of these technologies in the context of counterterrorism. And there'll be some on the call who will say, well, if we're in that terrorism space, you know, as rightly said, we have limitations on certain rights in international law. Not all rights are absolute. Rights can be limited. But in that context, I just want to remind us of a couple of maybe essential things. One is that the definition of terrorism, there's no global definition. We do have a Security Council Resolution 1566 that has parameters. We have a number of suppression treaties on terrorism. But in fact, if you look at national level legislation, the definitions of terrorism are the Wild West of definitions globally. The mandate tracks country by country legislative regulation on terrorism. And I'm not going to name countries, but for example, we have places in which large-scale protest of any kind against a government is deemed terrorism. We have countries in which tweeting support of human rights defenders is terrorism and can get you 15 years in prison. We have countries in which being a woman advocating to drive cars constitutes definition of terrorism under domestic law. So let's be clear on that specific question of the application of these technologies. Many countries are governing by the use of counterterrorism and security norms. So therefore, I think we have to the mandate comes to this discussion with a high degree of skepticism around the ways in which states are abusing terrorism, which is a real, as many of us know, those of us who've lived in violent societies know, there is a real core piece of work to be done by states on terrorism. But much of the work that's being done by many states does not fit within that definition. It is precisely the misuse of counterterrorism and misuse of technologies to broad phenomenon. So then keeping that in mind, the gap between the phenomenon of terrorism as defined by international treaties and the ways in which states are using the definition of terrorism, violent extremism, and increasingly just the language of extremism to regulate. That speaks to us of the really important need to regulate these technologies, because they have a wholesale use to a wide range of actors engaging in legitimately protected acts under international law. So that's where I would start to kind of remind us all where we're grounded in the conversation. Maybe just to focus on, EJ brought up, I think, a really important area and one that the mandate has thought about a great deal, which is this process of this context of data sharing. As I think EJ rightly mentions, There's enormous pressure on states to cooperate in the counterterrorism space. It's another kind of contemporary motif. And I think that raises a whole range of issues that I think are really in need of significant oversight. Cooperation is not a human rights free zone. And I think what we need to make sure is that in particular data sharing arrangements and practices are provided by law, and that they're strictly in compliance with principles of necessity and proportionality. And what I mean by that is we cannot have states outsourcing their problems to other states who have lower standards of protection on data simply because they know they're going to get caught domestically. So cooperation cannot become the space in which states do nefarious work by subcontracting to states or sharing with states who have lower standards of data protection, data that they have challenges using domestically. The other thing I think we have to be clear is that international cooperation cannot become an abusive human rights space. And I think that's particularly important to oversee and to have independent oversight of the activities of intelligence agencies, which are the agencies primarily operating in this cooperative space. The mandate has consistently called for independent domestic oversight of intelligence agencies, and we have some great examples of that. The UK, Australia, there are many countries who are doing that well and provide good models, but there are many states who are not. And so we need independent oversight of those agencies in order to ensure that their data use, including their cross-border data sharing, is human rights and rule of law compliant, right? So I just want to stress the importance and the importance of regulation in that space, and I think EJ has made that point, but also the absence of really precise and clearly defined obligation in that space at the current time.
Thank you so much, Daniela. Let's go to Ilia, to Privacy International. What's your view on this? Ilia?
I'm sorry, it seemed to have lost connection. Maybe it's better now. Yeah.
Yeah, it works. Yeah, please continue.
Yeah, thank you very much. I'm going to talk about transparency as well as a solution, but narrow it down to a more specific issue of transparency with regard to public-private surveillance partnerships. In the process of building and using the various biometric systems, there is an increasing dependency by states on the private sector to implement, but not only to develop these tools, but also increasingly to operate them and carry out surveillance functions that traditionally have been entrusted to the state. This raises serious concerns with regard to particularly accountability that was already raised. Mm-hmm. And one thing that follows also from a question that was before in the chat, speaking about the giants. One problem in these sectors, in border management and counterterrorism management, is that many of these companies, we've never heard of them. However, they are entrusted to execute very essential government functions. One of these companies, for instance, is Civil, which, fun fact, is partly owned by some of the largest arms producers companies. And in December 2016, Civil was chosen to set up and deploy databases to fingerprint everyone in Mali and Senegal. And going beyond fingerprinting, it is also involved in building full biometric ID systems in Senegal and Cote d'Ivoire. And all this is financed by the European Union in the process. In all this implementation, it is not clear whose accountability this is. And so transparency on who does what and for what person would allow also to have a clearer picture on who should be held responsible when such violations occur. There are plenty of other such examples, but that brings me to the second aspect that I think that needs reinforcement, and we discussed about it before, but this is exactly the remedial process. One thing that we tend to forget is often this kind of biometric databases are operated in border controls or other precarious situations where people are the most vulnerable. There are people on the move, people that seek assistance, people that want to unite with their family, and actually being able, while their data being processed by such systems, to challenge any mistakes that have been made in the process, it's very difficult. And so in the process, ensuring that appropriate remedial procedures are in place in such processes, it's essential, and also exactly to identify clearly who is responsible and who is accountable for mistakes, for false positives or abuses in cases. Is it the company? Is it the government? Is it the operator? Is it the system? But the right to redress involves exactly to be able to respond to that. So these are two of the key aspects to us. And the one last thing I would like to stress is that PI definitely supports CITED's call for a strong civil society engagement in all these discussions.
I can imagine that. Thank you very much, Ilia. Daniela, let's go to you. From your point of view, what's the way forward in Brazil?
Thank you. So I would say fairness, transparency, and accountability as the key words. We must adopt a strategy that aims to design a precautionary architecture of damages so that the use of the multiple biometrics should be preceded by its own proponent actions to mitigate its possible harm. So as the other panelists have already mentioned, the use of artificial intelligence for the collections and treatment of the personal data considered sensitive, such as biometric data, involves high risk to the rights and freedoms of the citizens that are difficult to measure. So the combination of a substantial risk and informational and power asymmetry point to the need to implement the detailed risk assessment and mitigation process. So as Fiona pointed, I'm sorry for the pronunciation, she said the gap, she talked about the gap of the phenomenon of terrorism definition and the misuse by the government, which is still those governments which still have the authoritarianism heritage. And as for example, Brazil, the important heritage of also racism heritage. So we need this detailed risk assessment and mitigation processes under the responsibility of those who control the use of this data collection and treatment technologies, and it must provide accountability and openness. So the requirement for a data is an international important trend. But however, depending on the details in this regulation of these assessments, the burden on holders of technologies that seek to treat biometric data varies. So consequently, the strength of the application of the precautionary principle varies in relation to the risk of the activity. So Brazil is one of the main characters in the continent, receiving lots of investments, not to say being harassed for some big companies just to receive for free some technological tools. And as the AI Now report 2020 has already called attention, regulating biometric is an urgent question, and we can see differences between the ongoing national policies and advocacy efforts to regulate biometric recognition technologies. And so I would point some of their recommendations and also some of the data privacy pandemic and privacy report recommendations, as the state should craft expanded biometric privacy laws that regulate both for public and private actors, the need to regulate the integration of public and private surveillance infrastructures, and the accountability of algorithmic impact assessment for AI's impact on climate, health, and geographical displacement. So I would also call attention for the guideline, the principal guidelines, as the the definition of the data life cycle, the reason, the motivation, the legal authorization, as well as a collection limitation principle, data quality, and purpose specification. So the use limitation also. In conclusion, I think the security of such technologies could trigger a system of co-regulation that would prevent a regulation based only on the command and control by the state. Thank you.
Thank you so much, Daniela. I'm conscious of the time. I know that the subject of biometrics and human rights you cannot capture in 1.5 hours, but I got the feeling that we just started. It's definitely something we need to discuss more and more. I promised ample room for Q&As, but I have to withdraw that because I know that the system, the Zoom system, can kick us out without any dispute. So we have to round up, and just let me summarize like 4 takeaways, key messages that I have heard. We've heard how the use of biometrics tools and data impacts on a broad range of human rights, including civil, political, economic, and social rights. And some of the challenges are common to data-driven tools, the normal ones, let's say, that we all know, but some of them are very, very specific to biometrics, and that needs an additional approach. And this has consequences for policy and legislation to be developed on biometrics and human rights. Second, it's emphasized that we need to be aware of the national security and counterterrorism context. As rights frequently apply in a modified, limited format, there are different interpretations of definitions of terrorism, etc. And this leads to reduced transparency and lacking of meaningful independent oversight, which was touched several times during the discussion. The third, apart from political will, we could state that lack of state compliance with human rights standards is frequently due to lack of capacity. So also here, technological and sufficient human rights expertise should be added. It's essential that stakeholders with human rights expertise play a role in capacity building, and we heard from CTAD the invitation to engage more on this issue with civil society organizations that might bring in a lot of expertise here. And then in relation to the business sector, the last one, there's insufficient attention paid to the role of business enterprises in this concept, despite these playing an increasingly influential role in counterterrorism, with states outsourcing public interest, what we just heard some examples. Finding ways to mitigate this gap is crucial for improving overall human rights compliance with biometric tools and their use. I'm looking at the panelists very quickly. If there is some very emerging issue you want to raise, you have the time now. I kind of sense the faces and
just want to say thank you very much for this panel. It was inspiring, and I have a lot of input that I want to take forward, and I hope that we will stay in touch. And please contact.
Thanks very much, Karen. Thanks very much, all panelists, for your very relevant input. You know, the participants, you know how to reach us. So is there any question for follow-up, anything you would like to bring in? The knowledge platform can refer you to the panelists and to everyone here in the room. So thanks again to all panelists. Thanks again to the knowledge platform and to the participants for this very excellent session. Wishing you a good day, a good night, a good evening.
Thank you.
Thank you very much.
Thank you.